Yes, Mr. Mond.
My Lord, just before lunch, I was addressing you on the exceptional circumstances point, and I had pretty well concluded my submissions on that. Our case is that the first instance judge came to his conclusion. The Court of Appeal found no error in that conclusion. And indeed, if one looks at Lord Justice Pill, in my submission, convincing argument, it was an entirely appropriate decision for the first instance judge to take. But in the absence of an indication or finding in the Court of Appeal that an error of law was made or any other error was made, in my submission, there's no grounds for overturning that decision in the Court of Appeal. None is identified, and the basis of Lord Justice Arden's own decision is not one which squares with the legal test which he has accepted and which the first instance judge has set out below.
Yes.
So those are the matters I wanted to put before you on that particular topic. But I do invite you to read through Lord Justice Pill's dissenting judgment on this issue, because I can't put matters any better than he does there, and I failed to do that, I think, in my case. Now that takes us to the final and, I hope, short point, which I call the no better position point. And your lordships will know what I mean by that. It's a reference to the passage in Haim that the derivative beneficiary can be in no better position than the trustee in whose right he seeks to sue. Now, can I take you to one authority we haven't yet seen on this, and that's Parker and Tweeddale. Partly because it's maybe of some use in relation to other matters we've been looking at today. That's in volume 4 of the authorities bundle at divider 48. In the Parker-Tweeddale case, Mr. Parker-Tweeddale had been having domestic difficulties with his wife. They had been engaged in negotiations over the family assets leading up to a divorce. And the result of those, as far as we need to know for this purpose, is that the wife was sole legal owner and also sole mortgagor of the family house. But she held that house upon trust for her husband after the mortgages had been discharged from it. So he was a beneficiary under the trusts of that house. The wife consented to a sale by the mortgagee, Dunbar Bank, at a price of £575,000. Before that sale was completed, the purchaser sold it on, flipped it as the term is, at a price of £700,000, and that caused deep concern for the husband. He initiated proceedings pretty well straight away to try and stop that happening. And those proceedings he initiated against Dunbar Bank, the purchaser from Dunbar Bank, and his wife as well. By the time they got to trial, he had come to terms with his wife about the claim in the estate, in that action. So he continued the action. He'd started the action against his wife, who was his trustee, and against the third party mortgagee, Dunbar Bank, and against the fourth party, as it were, the purchaser. And if I can take the report doesn't, as far as I know, set out exactly the way the matter was pleaded. He was a litigant in person, so it may be that it developed as the case went on. But essentially, you will see there were two different claims, rather reflecting the position in this case. The first claim was he had a claim against Dunbar Bank, the mortgagee, he asserted a claim directly of a duty owed by the mortgagee directly to himself as a beneficiary under the trusts. And that was dealt with by Lord Justice North at page 19, D, under the quotation, the piece quoted. He says, once it is recognised that the duty owed by the mortgagee to the mortgagor arises out of the particular relationship between them, it is readily apparent that there is no warrant for extending its scope so as to include a beneficiary or beneficiaries under a trust of which the mortgagor is the trustee. So he rejected, the trial judge below and the Court of Appeal upheld that, rejected the claim that there's a direct duty owed to the claimant as a beneficiary under the trust by the mortgagee Dunbar Bank. The mortgagee's duties were owed solely to the mortgagor, who was trustee for the claimant. The correctness of that view was fully established in the clear and compelling argument of Mr. Lloyd, carrying on at E, who drew particular attention to the rights and duties of the trustee to protect the trust property against dissipation or depreciation in value, and the impracticabilities and potential rights of double recovery, and here only giving the beneficiary an additional right to sue the mortgagee, a right which is in any event unnecessary. The only exception for which Mr. Lloyd allowed was a special case, where the trustee has unreasonably refused to sue on behalf of the trust or has committed some other breach of his duties to the beneficiaries, e.g. by consenting to an improvident sale, which disables or disqualifies him from acting on behalf of the trust. In such a case, the beneficiary is permitted to sue on behalf of the trust. This exception established a series of authorities leading up to Haim and Citibank, and then there's quoted that passage. It's important to emphasise that when a beneficiary sues under the exception, he does so in the right of the trust and in the room of the trustee. He does not enforce a right reciprocal to some duty owed directly to him by the third party. And he goes on to say, as I've said, the plaintiff reached a settlement with the wife before the trial began. That meant that he could no longer pursue against her his claim she had given her consent to the sale in breach of trust to him. But both here and below, the argument has proceeded on the footing that if there was in truth a breach of trust by the wife, the plaintiff's settlement with the wife did not preclude him from suing Dunbar in right of the trust and in place of the wife. Accordingly, the question whether Peter Gibson J. ultimately had to ask, the question which Peter Gibson J. ultimately had to ask himself was whether there was a breach of trust by the wife in giving her consent to the sale. So they've already excluded the direct duty, and then they find that there was no breach of trust by the wife, or the first instance judge finds that at C to D. Then at D, the judge accordingly held that just as the plaintiff had no cause of action against Dunbar as a beneficiary, so he had no cause of action in right of the trust. It is observed that the essential basis of that holding, namely the finding that $575,000 was a proper price, would also have defeated the claim based on a duty owed directly by Dunbar, the plaintiff, had such a duty existed. So here we've got the same set of facts, but the Court of Appeal here is talking in terms of two different causes of action. One being the beneficiary's cause of action, and the other being the cause of action in right of the trust.
How does one apply that to this case?
Well, in this case, in my submission, there's a close analogy, because it's been my submission all along that there are two different causes of action. One is the direct cause of action by the beneficiary, alleging a direct duty to him. That was the cause of action which was rejected earlier on in the judgment, and which is referred to as the plaintiff having no cause of action as a beneficiary. Then he says there's the alternative cause of action, no cause of action in right of the trust. It's the derivative claim on behalf of the trust, run by a beneficiary in the right of and in the room of, right of the trustee in the room of the trust, or vice versa. So exemplifies that the Court of Appeal, in this case, regarded those two as different causes of action.
So are we back to subsection 2A? So I thought we were on some new point.
Yeah. I was intending to come on some new point, but when I looked at the case over the shorter German, it struck me that that was of some assistance in the arguments this morning I was trying to put forward about there being a different cause of action in respect of.
But here it's one which is based, you accept, on essentially the same facts,
Yes.
or substantially the same
Yes,
facts.
I do. But what I do take for this, now we come to this issue about the no better position argument, it is the description, Lord Justice Nurse's somewhat graphic and metaphorical description. The beneficiary sues in right of the trust and in room of the trustee. And
What does in room of the trustee meant? I mean, I haven't heard that expression.
no, nor have I.
Whether that's maybe a Scottish expression, but I have.
Well, if it is, I'd be grateful for any assistance on it at all. Perhaps in the shoes of the.
Shoes. Yes, that's
yes,
what I put in.
It's you're.
But I don't suppose it matters.
I don't think it matters. No, absolutely right. But the essence of it, though, is that if it is correct, as said in Haim and as reflected in that dictum in Parker Tweeddale, that the claim by the beneficiary, the derivative claim, is brought on behalf of the trust and cannot be better than the trust's own claim, then how can a derivative claim be allowed in this case, we ask, when the estate's claim, the trust's claim, is time barred? Because otherwise, the complete answer and simple, short answer to any claim by the estate is circumvented. Now that's the point the Court of Appeal didn't consider it necessary to consider because they'd already decided the case otherwise against the claimant. I've set out in my skeleton argument the facts in the Haim case.
Yes.
But it's not the facts that are the crucial element to it. In the Haim case, it was, in fact, sought to be argued that the special circumstance in that case was that by carrying on a derivative action, one could get round a defence which would be otherwise valid against the trustee's claim.
Well, the point really is very short, isn't it? It's page 18, little f. You bring the point out into focus there. Point you've just been making, really.
Yes. But in the Haim case, the counsel tried to suggest that there was a special circumstance, because you could actually, by the beneficiary bringing a claim, a defence that would have been, that the trustee might have been defeated by, wouldn't work. And that special circumstance should allow the derivative claim to go through. That was rejected by the Privy Council. They said, no, that's not a special circumstance. In fact, it's not a circumstance at all, because all claims that the third party can operate and apply against the trustee also apply and operate against the derivative claim. So if that's true, how can a derivative claim be launched outside the limitation period when the estate could not bring it itself?
Is this quite apart from Section 35?
Yes,
Is it?
it is.
So the trust would have to start its own action, would it?
The trust, yes, the trust would have to, but can't. I mean, the trust can't. And because the trust can't, the derivative claim should not be allowed either.
So the assignee, as it were, or the that's the right of equity, couldn't avoid that by simply serving the proceedings on the trust.
No, because what he's doing, this beneficiary, is it's not a question of matter of service. He is suing, he is exercising his right as a beneficiary to bring the trust's own action. And that trust's own action would fail in limine. And somehow, if this were to go through, he would get, well, as a graphic example, the revenue and other beneficiaries of the estate would, if the action was successful, recover large sums of money which they have otherwise lost the entitlement to recover at all. The estate would obtain a benefit which it has ceased to have the benefit, have the advantage of.
So you say this, the estate's claims are bad either because of Section 2 or Section 5 of the 1980 Act, is that right? Which are the simple limitation points for tort and contract.
Absolutely right. Absolutely right, yes. Exactly. And there can be no doubt about that.
So we wasted the last 2 days,
We
really.
did.
I mean, this would be a very simple answer.
Yes.
To this point occurs the Law Reform Committee.
It doesn't arise with the law reform committees because the law reform committee regard a stranger who's started an action in right of the trust. Sorry. A beneficiary who started a derivative action in right of the trust has got his action on foot. And all he needs to do is to join an extra party to correct that right. So that the trust's action is already on foot because it has been commenced. It's just that the private party needs to be joined to it later. Here we're in a different position. The trust action hasn't been started and the trust could not bring any action at all.
And the Court of Appeal didn't spot this as a simple way around the arguments that they had to deal with.
No.
Did they? I mean,
No.
this came in at the end of...
But it would be a very simple...
I gave it to the Court of Appeal. I gave it to Justice Morgan, who didn't deal with it. Well, he didn't deal with
Oddly,
it.
you might have thought this would have been taken as a preliminary point. We could have avoided many, many days of argument.
Well, I made the
because it
submission.
would be the answer.
It
Full
would.
stop, over in 10 minutes.
I made the decision. I made the submission to Justice Morgan, and I thought it was the killer point there. I remember I had it written in large letters at the top of my skeleton. I repeated it in the Court of Appeal, and it didn't need to be dealt with. It wasn't dealt with by any of them.
Sorry, I haven't picked up. Did Mr. Justice Morgan deal with it?
Not in his judgment.
He didn't in his judgment, I know, but was it?
I argued it before him.
Right, sorry,
And
I see.
He didn't find it a convincing argument, but I didn't
Right.
get any explanation from him.
Yes, and then you repeated in your notice in the Court of Appeal.
Yes. I argued it there, and somehow it got left there too.
Did you start with it or did you end with it?
I can't remember. I have a horrible suspicion I started and ended with it. Because it's the only thing in the case that I've been able to vaguely understand, at least the proposition. I haven't understood the alternative answer to it that would do me down.
Well, it's a short point.
It's a very
That's
short
just
point, and
about
I can't improve
Is
it.
there any support for it in Lewin?
Lewin quotes that phrase in the right of and in the room of the trust.
Yes, but that's not quite the same thing.
It's not quite the same thing, but it's Lewin is essentially a shortened form of valorization of Haim. That's what and some of the other authorities which of course are run through in Haim. So, but I can let you know. It's quoted, isn't it?
Just trying to work out how this argument fits in with Section 35(1) in the simplest case of all you can imagine, where the derivative action is really a real mirror image of the so-called principal action. I mean, there's nothing to choose between them really, except that one is brought as a derivative. But the trustee owes a duty only to the person who brings the action. If the trustee brought it as a fresh action, of course, he'd be caught by either Section 2 or Section 5. But Section 35(1) is preserving a situation, isn't it, where you backdate to the date of the original action.
Yes. What my argument presupposes, in a sense, if you like, is that there may be some limitation mechanism whereby the claimant could squeeze it into his action, because otherwise it just doesn't arise.
Yes.
But then one looks at the principle which appears to sit on top of the derivative action, which is that a claimant bringing a derivative action can't be in any better position
And when do you test it?
when the derivative action is sought to be brought.
At the date of the issue of the claim form?
No, because that's not a derivative action.
So do you test it as at what date then? Take this case.
As the date of the amendment is considered. As always, the amendment, until the amendment is made, till the order is made, there is no amendment. So you test it at the date at which the amendment is being applied for. You don't test it on the basis that you've given the very amendment which you are considering.
Suppose it isn't an amendment case, and you start your proceedings as the as the beneficiary. You start your proceedings, the derivative proceedings, within the time limit, and by the time of the trial, still no proceedings have been started on behalf of the trustee.
Well, then you test it when the derivative claim is made. I accept that. That's no difficulty there. The derivative claim is made, and when that claim is made, the beneficiary can't be in any better position than the trust. But he gets the derivative claim started, and it is a claim on behalf of the estate, on behalf of the trust. So that claim has already been started and is expressed in those terms. So it's on its feet.
So when he brings the claim, that is a claim on behalf of the trust.
If he says it is,
If he says it is, even if the trust
phrased in that way,
isn't joined. Take this case.
if he brings a claim on behalf of the trust, yes, then that would.
But if that's right,
but if he brings
if that's right, and the derivatives claim is preserved by Section 35, then he's okay, isn't he?
No, because when he brought the claim, it was a claim purely for his loss, not for anybody else's. And that was his net loss after he'd done all the calculations. The estate...
No, I'm assuming for this purpose that the derivative claim... Suppose the derivative... In an ordinary case,
yes,
you say that
right.
if the derivative claim is in time,
yes,
then he's okay.
Yes. He is,
because they may have to join them.
I'm sorry, but he has, in his own proceedings, launched the right of action, which is the estates or the trusts. Yes, right. Exactly.
So but my question is whether, if that claim, let's say the derivative claim, is preserved by Section 35, then he'd be okay, would he?
Yes.
There wouldn't be any independent point.
No, if the derivative claim had been launched...
So we're back to Section 35. On that footing, this isn't an independent point, is it?
Well, it is, because once the derivative claim is launched, the third party, the solicitors, never have a statutory defence to the estate or trust's claim. Never have a statutory limitation.
Now, we're assuming for this purpose that you're wrong so far.
Yes.
And so the derivative claim is now treated as in time.
That's the effect of Section 35.
Yes, that's the effect of Section 35. In which case, this point is no good for you, is it?
No, because it hasn't happened. We're looking at the time when the amendment is to be made. I mean, as I understand, until an amendment is made.
So would
Section
it would
35
go
hasn't been...
it would go to the discretion of the court to order an amendment, would it? Nothing to do with Section 35.
Yes,
But this amendment should not be allowed because it would put the beneficiary in a better position
Yes.
than the trust.
It is a discretionary thing, you're absolutely right.
I mean, this is terrible ignorance on my part, so please forgive me. I mean, are things called derivative claims because they derive, the party's claim derives from the claim, in this case of the estate, or in another case of the company? I mean, is that why they're called derivative? We use this term all the time.
We do use the term, and it becomes a label, and then as soon as it becomes a label, one can't see what its significance is. I do not know why that label was first chosen, so I can't tell you exactly how it works.
Well, presumably the claim of the shareholder's claim or the beneficiary's claim derives from, and only has an existence insofar as there's a claim available to the company or the estate.
Yes, it must do it.
And if that is so, I mean, you say, unless I'm mistaken, you say, well, actually, you say the company, the estate here wouldn't have a claim because it's time barred.
Yes.
That's
Yes, that's it.
So you can't get a derivative claim.
Yes, except the time bar, of course, is a procedural bar, isn't it? So that it has a claim,
Yeah,
but it can't be pursued.
exactly.
Yes, but the effect is that if you were to allow the estate to overcome that, vis-à-vis my clients, the third party, the estate would then be in a better position,
Yes.
far better position, which is what Citibank says you shouldn't do.
So if it were a matter of discretion in the amendment, on amendment, that would be a major factor, but it wouldn't necessarily be a knockout blow if there were other important reasons of justice why the claim should be maintained.
Well, the way the principle is put in Haim
Yes.
is that you cannot be in a better position than the trust estate. In my submission, it would be a knockout.
Yes.
But I still don't quite see what your answer to the Section 35 point is. I mean, I quite see that, but you assume you start your, well, I'll call it a derivative action, might not be accurate, I don't know, but you start your action in your name on behalf of the trust, which is what
Yes.
that action is. It is out of time on the face of it. Or, sorry, you seek to amend on this basis, yeah.
You started derivative action within time, you're saying?
No, I'm saying you start a derivative action out of time,
Yes.
and you want to add it by way of amendment to an existing claim, as in this case. And so you then look at Section 35 and see you're within Section 39. And if you are within Section 35, then your new claim shall be deemed to have been commenced on the same date as the original action. So that makes it in time, and that defeats this point.
But what happens is, on your supposition, you have a claim that's already on foot, which has the same facts. After the limitation period, you apply to bring a derivative claim. That application, I say, is rejected, because when it's made, the court sees that the estate or trust would not be able to bring a claim, and therefore it says, well, we can't improve the trust's position completely in breach of that principle, therefore no amendment lies now.
Well,
It's not a Section 35
I
point.
still don't understand that. This is all on the assumption that you're wrong on the major argument. That would mean that that Mr. Bloom's correct, that it survives the scrutiny under the subsections, and you just have the simple proposition in Section 35(1), which assumes, but for Section 35(1), that it would have been caught under Section 2 or Section 5. I mean, as I understand it, the purpose of Section 35(1) is to get past the basic rule, which would otherwise apply in cases which fall within its terms. So, as I see it, it comes down to the exercise of the discretion, which I assume would be the Rule 17.43 discretion, which is allowing an amendment, or 4 rather, Section 17.44, allowing an amendment to alter the capacity in which the person is suing.
on this assumption, I've lost, have I, on the section 35 point, so that there isn't any, section 35 does not itself provide a bar to an amendment in favour of the appellant. But that amendment hasn't yet been made. And this is the first time at which a derivative action is sought to be brought.
Yeah.
And the estate will be out of time, so the amendment is not allowed, because otherwise the principle will be infringed.
Let's assume you're wrong in saying that it's necessary to join the personal representative or the trustee. So you've lost purely on that point on section 35. You say, well, that still doesn't resolve the question whether the amendment should be made, because the trust would still have had its limitation defence if it had been joined.
And am I right, that's an exercise of discretion under Rule 17.4
Yes.
for the capacity amendment,
Yeah.
which is discretionary? Well, is there anything more you'd like to...
I don't think there's any more I could possibly say, unless there's any further. Assistance is not the word, but assistance I can give you.
Well, thank you very much indeed for your assistance. Yes, Mr. Blome.
My Lords, can I start by dealing with the 2 points in the respondent's notice before responding on the main point?
Indeed, yes.
Your Lordships are content with that course of action. Dealing first with the special circumstances argument, as your Lordships will see from the appellant's case, we say in terms that there is properly considered no difference between the exceptional circumstances, special circumstances and fair in the justice of the case tests that have been referred to in various cases. As I understand it, Parliament is quite keen to use exceptional circumstance and special circumstances in its statutory legislation, if perhaps only because it gives the impression of being highly restrictive and leaving matters to judges to decide otherwise. But on the footing that they are the same, and I don't think Learned Friend takes issue with that, it is, we say, noteworthy that Lady Justice Arden's analysis at the final conclusion asserted that the fair outcome in the litigation and the application was that this claim be permitted. She said the fair result in the circumstances of the case at paragraph 45 of her judgment. In our submission, that was a view that she was entitled to reach on the basis that Mr. Morgan QC, as he then was, had approached his task by falling perhaps into the trap that he may have been led by the way the matter was approached forensically and analytically by counsel before him, of searching through or subdividing up the facts of the case into various particular issues, and then asking him the question in respect of each issue or gobbet of facts, is that a special circumstance? And he worked through them, having subdivided them up into 18, and considered that none of them were special circumstances. That appears to be, if I might say so, the gist of paragraph 50 and 51 of His Lordship's judgment, and that's at pages 33 and 34 of Divider 5 of the core bundle. Paragraph 50, we have the 18 subdivided relevant circumstances, and that appears under the subheading, are there special circumstances in the present case? If one turns to the judgment, paragraph 51, His Lordship says, in the list of circumstances in paragraph 50 above, the circumstances listed in paragraph 1 to 16 do not, in my judgment, amount to special circumstances justifying a derivative action within the authorities to which I've referred. So it appears that he considers those matters. It would appear, we would suggest sequentially, puts them to one side. Does one or other or both of the circumstances in paragraph 17 or 18 amount to a special circumstance? He then looks at those individually, says no, they don't fit the bill for various reasons, and therefore the premise, the conclusion that he reaches from that premise is that there are no special circumstances. In my submission, His Lordship appears to have fallen into the mindset described by my Lord Clerk of analysing step by step each of the circumstances separately, and in a complicated case such as the present, what he should have done is simply taken a step back and said, looking at all of the relevant matters here, do I find that there are special circumstances in this case as a whole, rather than do I find the existence of any category of special circumstances in the case. In this respect, it's rather misleading simply to say that the categories of special circumstances are not closed, because what that seems to indicate is that you have to bring your case, your claim, within the yardstick of a particular category if one is to succeed. And in my submission, that approach is apt to lead to almost a tick box approach, rather than an approach which says one has regard to the entirety of the matters. My Lords, in my submission, read fairly, that is a conclusion that can properly be ascribed to the judgment of the Court of Appeal, in view of Lady Justice Arden, with whom Mr. Justice Patten agreed. And in those circumstances, the Court of Appeal was entitled to take its step back and to ask itself in the round, are there special circumstances?
But I'm not quite sure what the reasoning in paragraph 45 in the Court of Appeal is. What's the error which Lady Justice Arden identifies? And then what's the basis on which she considers there are special circumstances?
Well, my Lord, the error appears to be an error relating to the methodology of approach to special circumstances rather than a particular labelling of special circumstances. The approach of Lady Justice Arden is to say that looking at the facts as a whole, the fair result in the circumstances of the case would have been given permission to amend.
Where does she identify the error? Mr. Morgan wasn't guilty of what she criticises in 41, was he? She isn't saying that he did that.
Well, my Lord, I rather fear it is. If one looks at the judgment of Mr. Morgan as a whole, it's quite plain that he's gone through the issues which might arise in the proceedings paragraphs 21 and onwards.
Well, just assuming you're right on that, what reasons does she give in 45 for saying there are special circumstances?
Well, my Lord, Lady Justice Arden simply asserts that that's the fair result in the circumstance of the case. The material circumstances that she sees are that this is a potentially valuable asset,
Yes.
that the claimant has funding to bring it.
But somewhere she says that it's common ground, I thought, that funding... Oh, it says no objection, I see, that's 44.
Yes,
Yeah.
and indeed that's right. And perhaps this is where the funding point has perhaps gone off at a slight angle. The usual argument is that if a party is legally aided, then that should be an adverse factor in respect of their asserting or asking for the assistance of the court because of the fact that a defendant to a legally aided claim will not be able to recover costs in the event that he's successful. So that's some sort of prejudice. And the relevant section under the Legal Aid Act 1988, as I understand it, it requires the court, in effect, to treat a legally aided party as being a privately funded party for those purposes, so that that element of prejudice, as it would work into the court's exercise of its discretion, in fact has no effect. It's taken out of it entirely. But that doesn't mean that one should ignore the fact that this claimant was funded. The fact of the matter in this case is the claimant was funded. The oddity that arose from legal aid is that he could not use that funding to pay it over to the estate for the purpose of the estate bringing a claim. And if he was privately funded, if he had money in the bank, he could have done that. He could have funded the estate to bring the claim. But that wasn't the position here. The estate was insolvent, it had no assets, and worse still, we say, the reason that it had no assets and couldn't bring the claim was because the defendants in this case had either poorly advised or poorly acted as regards the estate, and so made them impecunious in the first place. And in those circumstances, it was obviously, whether one calls it the fair result or one says there are special circumstances looked at in the round, there was a good and proper case for this claim to be brought by a party interested in the estate.
I'm slightly confused in my own mind about whether what we're considering here is whether one considers this differently, because one is considering whether at this stage to allow an amendment to bring in a derivative claim, and whether that's different, the test is different in that situation from what the test would be, supposing that he'd begun the action as a derivative claim. Because this talk, Lady Justice Arden is talking about there is no evidence that the claimant made a deliberate decision at an earlier stage not to bring a derivative claim and then changed his mind. That's paragraph 45. In other words, it's as though what's being considered is whether the fact of what's happened and so on is relevant as to whether or not he should be able to bring a derivative claim, as opposed to just the question. I mean, it seems to me there might be two questions. One is, would these normally be the kind of case where it would be special circumstances for allowing a derivative claim? And secondly, if that's how Lady Justice Arden's analysing, whether or not in these circumstances, given the way he has behaved in the past, he should be allowed to make a derivative. Now, is that the way you look at it?
Special circumstances, we say, requires the court to consider all of the material circumstances as they are relevant to the bringing of the claim itself, the derivative action itself. There may indeed be an overlap between questions of special should you in this case bring a claim, and whether in general terms an amendment should be allowed. The matters are both matters of the exercise of the court's discretion. In both cases, the court is making a value judgment and is having regard to matters that relate to the claim itself and the way the way in which the party either is or is not able to bring a claim. It must look at the history if it's going to consider special circumstances.
But does it not have to test it at the moment of the issue of the relevant claim, as either at the time of the original action, if that is a claim on behalf of the estate, or at the time of the proposed amendment?
Well, that would be right, because
And obviously you have to take account of everything that's happened up till then.
yes, and well, the reason that is right is that the special circumstances themselves primarily, although not exclusively, primarily relate to the reason why the legal party can't bring the claim or hasn't brought the claim, and why the actual party or the beneficial party should be allowed to bring the claim. So obviously those matters arise between the cause of action itself accruing and the actual decision that's made either to bring the claim in the first place or to amend to insert it. So it has to have regard to the entire relevant history. There may be matters that are irrelevant, but it must have regard to the entire relevant history.
That seems to be what Lord Templeton was saying in Haim, which is quoted in paragraph 40 in the Court of Appeal. One's got to have some sort of context for what one's talking about in special circumstances, and it's
Yes.
which they embrace a failure by the trustees in the performance of the duty owed by them to protect the interests of the beneficiary.
Yes, I mean,
And-
well, the oddity here is the use of the phrase failure excusable or inexcusable. An inexcusable failure, one can understand, that's a breach of trust, that's misbehaviour on the part of the trustees. An excusable failure may be a quite understandable action on the part of the trustees in which they decide that they can't bring the claim, or it's entirely inappropriate for them to bring the claim, as opposed to asserting the claim is worthless. And that might be a case such as the present, where where the estate itself is insolvency and the trustees can't take on the personal liability or get funding to bring the claim itself. So, my Lord, I'm happy to accept that it's a matter of discretion. It has regard to all of the relevant facts, but those must be the relevant facts in respect to the bringing of the claim. An irrelevant fact, for example, might be that a claimant is otherwise in impecunious circumstances and needs the money a lot. That wouldn't be a special circumstance. It doesn't derive from the relationship between the beneficiary and the trustee. But this is otherwise a relatively wide-ranging analysis that the court is being asked to carry out.
I have the impression, looking at paragraph 45, which has been referred to, that some of what Lady Justice Arden is discussing there isn't matched exactly by the list of circumstances set out by Mr. Justice Morgan. It's quite difficult to match them sentence for sentence by what he was saying there. And although she doesn't say so in terms, it may be that what she's saying is, in fact, what you've been submitting, that really you mustn't be have a checklist of individuals. You step back from the whole thing and decide whether or not it's, as you put it in your case, whether the justice requires that this should be done, given the failure by the administrator to do what he should have done.
My Lord, that is how we would invite a court to address that particular question. It might be helpful just to refer back a little bit in the judgment of Lady Justice Arden to paragraph 21, in which, having set out the authorities relating to special circumstances, Her Ladyship then set out the argument that was put forward on behalf of the appellant, which is that the principle that is sought to be extracted from those authorities, this is at page 12,
Yes.
is whether in all the circumstances justice requires that the beneficiary should be entitled to bring a claim. He submits that in this case the judge took too narrow a view. If the claimant could bring a claim, an asset could be realised, and then sets out the other matters that are put in support of the application. That was the case on appeal that was being put forward on behalf of the appellant, and that was a criticism of the judgment below, and it certainly appears as if Her Ladyship accepted that was the correct way forward, and it certainly by implication appears that she accepted that was a valid criticism to be made of Mr. Morgan's judgment. My Lord, I think that probably summarises our case.
Yes, it's a short point, but I think we can see that what you're submitting. And we can read, of course, what you have in your case in paragraph chapter 5.
Yes, I'm
page,
grateful.
paragraph 5.1 and so on. Well, that's working backwards, that's special circumstances.
There's
no better position.
No better position, yes. My Lords, this is the shortest part of the respondent's case, and it really comes down to this, that of course the principle as set out in Parker, Tweedale and Haim is accepted, that a beneficiary who enforces a trustee's case should not be in a better position than the trustee enforcing that case. Of course, neither Parker, Tweedale nor Haim concern limitation points. There's no consideration of how that would work out in the context of limitation. And as far as the application to amend is concerned, it is important to stress, what mustn't be lost sight of, that this is an application to amend an extant claim brought by the claimant against the defendants. It's not a case of the claimant bringing a fresh claim now without any former claim in existence and simply seeking to assert the trustee's right. And this, I'm afraid, in my submission, really goes back to the same question that we've spent so much time discussing as regards Section 35. Section 35 raises the concept of relation back and applies that to new claims. If it's the case that this new claim relates back, which the statute indicates it should do, then the consequence is that when a person is in our position, having brought a claim, there is no limitation defence. If, on the other hand, we fail by virtue of Section 35, then we fail. So it's really an equitable seizure of a principle that's already encompassed in statute. And our primary submission is that this takes the matter no further. As I understand the matter, certainly, maybe that my learned friend will concur with this, certainly that was the indication of the Court of Appeal, although it doesn't form part of the judgment, that was why they didn't want to deal with the matter, because they thought certainly that was an arguable point, even if it wasn't necessarily a conclusive one. And in my submission, it comes to your lordships essentially on that basis. It adds nothing to the claim.
Why shouldn't it still remain as a separate point on discretion? Because even if a result, unintended or probably unintended result of Section 35 is to allow the amendment to be made, nevertheless, if there is a general principle that a beneficiary suing in a derivative claim shouldn't be in a better position or can't be in a better position than the trust on behalf of which he sues, that shouldn't go to discretion to amend.
Well, my Lord, as your lordship indicated, of course, all sorts of matters go into the discretion to amend if one's not considering a bar but considering a discretion. And of course, one of the main things that would go into the exercise of the discretion to amend would be matters such as prejudice. Another matter that would go into the general discretions to amend would be the policy of the 1980 Act. And as has become apparent in the course of this appeal, the policy of the Act is to allow claims to be made if they arise out of the same or substantially the same facts as those already asserted.
No, the policy here, I think, is to ensure that procedural defects in the original action didn't prejudice a claimant.
My Lord, I think I'm referring to I think it's the judgment of Lord Justice Hobhouse in Good and Martin, which I think is cited in Smith-Henniker, in which his lordship indicates that that was the policy underlying the Act, and that is a policy that stale claims be not litigated.
Oh yes, no, the policy of this part of the Act.
Well, if one's looking at matters of policy, my Lord, looking at the Act in general, I appreciate that this dances around your Lordship's point before answering it, that the general policy is that stale claims will not be litigated, but claims which have been brought in time will be, that's the corollary of that changes in capacity will not bar a claim as regards existing actions, and also we would say, and this comes into section 35, that mere procedural amendments should not fall within and do not fall within the Limitation Act.
Procedural defects shouldn't defeat a claim.
Yes, if that is what this is. But if the oddity in this case on the main point is that, as has been pointed out in discussion, if this were only a change of claim, if this were only a change of capacity, or perhaps if this were only a mere procedural alteration on our case, this wouldn't be a problem. The Act itself would not bar this claim. But because it's a combination of all of these three things, we are being barred. That's the allegation that's being made. And so certainly if one looks at it as a matter of policy, one could quite properly turn to the court and say, in these circumstances, is it fair that we be prevented from amending? And the answer, in my submission, would be no, that isn't fair that we be prevented from amending. But of course that would be a discussion on discretion, where all the matters that my Lord raised came into play. My Lord, that goes beyond the case we set out in our appellant's case, because it also deals with the matters that my Lords have raised and my learned friend has raised. Well, I think that deals with all of the matters relating from the respondent's notice, unless there are any other matters relating from that I can deal with.
Yes, I think you can move on.
I'm grateful. Lord, if I can respond to my learned friend's case on the appeal itself. Learned friend concluded by indicating to your lordships that this case really all turned on section 35 and the rules. And I agree with him, it does. This is a case that turns on statutory interpretation. But the difficulty is that it's statutory interpretation against a background of the extant law. As your lordships have noted, one of the main issues, statutory interpretation, that we've looked at relates to the word involving in section 35 subsection 2 of the Limitation Act. And as your lordship knows, my case is that any claim involving the addition or substitution of a new party does not mean any addition or substitution of a new party. It means involving for the purpose of constituting a good legal action, where that is necessary. Learned friend, as I understand it, says no, involving simply means what it says. It's the literal meaning. Whenever you have to add a new party, that bar comes up.
So you say for the purposes of good...
Purposes of where a new party must necessarily be added in order to constitute a good action at law.
Good legal action at law.
in slightly different words, that's the legal obligation half of the dichotomy that I mentioned in opening, as opposed to procedure. Now, in construing that subsection, your lordships have been taken to the enacting history of the pre-enacting history of the section by way of the 21st report of the Law Reform Committee, which was published in 1977. That's in volume 1, divided 4. Well, the first point I make is this, that the passage that deals with this amendment, which in fact runs from paragraph 5.16 to 5.29, pages 68 to 73 of the report, 5.16 is under amendment to add a party, and that goes through to the end of the extracted section. It's quite plain that the Law Reform Committee did not think this amendment applied, section 35 applied to any application to add a party. Their discussion of this matter related to certain specific areas only that they set out. And those cases were set out, the relevant paragraphs, some of which your lordships have been taken to, 5.17, that's the Hudson and Fernie-Huff citation, and over the page, the categories they were looking at, 5.20, 5 areas. Now, the reason why the Law Reform Committee thought that those areas had to be addressed was because they were cases in which, in the view of the Law Reform Committee, it was necessary to join a party in order to constitute a valid cause of action at law. And that is apparent, I'd say, not only from paragraph 5.20, but also, if one turns over the page, from paragraphs 5.26 and 5.27. 5.26 states, the evidence we have received, and here again we're greatly indebted to the senior master, shows that under the current law it's by no means always easy to distinguish a correction of a misnomer from the addition of a genuinely new party. It would inevitably be at least equally difficult to distinguish by reference to a generally acceptable formula between a party whose joinder was a mere technical necessity and one whose joinder substantially altered the scope of the action. It would not, for example, be sufficient to confine any extension of the current rules to the joinder of a new party as plaintiff, though in practice joinder of a party as a plaintiff may well be merely a technical necessity, because a necessary party who declines to be joined as a plaintiff must be joined as a defendant. And we also consider that the case described at paragraph 5.25, that's suing to recover from persons jointly but not severally liable to him, but only having joined fewer than all of them. Moreover, the addition of a new party, as for example co-plaintiff, will expose him to the risk of becoming defendant to a counterclaim or the object for an order for costs. Well, pausing there, the reference to the new party's addition is a necessity, italicized, is in my submission a plain reference to a legal necessity, otherwise the cause of action, otherwise the claim cannot be brought at all. 5.27, the committee attempts to synthesize the common factors to the cases we have identified above, and perhaps this is important, and likely to be common to any analogous cases on which Parliamentary Counsel could draft a satisfactory formula. These factors are, A, that the plaintiff's action is not properly constituted unless the new party is joined, and B, the plaintiff is not seeking any substantive relief against the new party, though for reasons we have given, that party's joinder may in the event involve him in substantive liability, or if he is seeking such relief, it is sought against a person who is jointly but not severally liable with an existing defendant and whose joinder is necessary if the plaintiff's claim against the defendant is to proceed. Accordingly, our conclusion is A, that the rule-making power should be extended so as to permit the post-limitation joinder of a new party in the circumstances we have identified and in other analogous circumstances. Well, the common point with all of the circumstances identified is that it was, in the view of the Law Reform Committee, no good cause of action until the party was joined. It was a matter of legal necessity. I would note that when setting out their categories, the committee appears perhaps to have expressed itself in rather stronger terms, certainly than the supporting authorities dictate. If we go back to 5.21, the reference is to where the plaintiff is beneficially entitled in equity and the person with the legal title is a necessary party to the action. For example, the equitable assignee of a shows in action who cannot sue without joining the legal assignor. And the footnote for that refers to Performing Rights Society against London Theatre of Varieties. And as we know from having examined that case, that is not a case where a party cannot sue. There was no problem with suing. The problem in that case arose in the fact that the court was not going to allow the party to go to judgment in those circumstances without joining a particular party.
Yes, but point 4 is the crucial one, isn't it?
Yes, my lord, exactly. It is crucial because that is an example, according to the Law Reform Committee, where the claim is defective. It cannot be properly maintained unless the company is a necessary party to the action. Well, my lord, my whole submission is that the joinder of a party in that position, whether it's a company, a trust, or indeed the legal owner of a writing contract, is not a matter of necessity. They are not necessary parties to the action in that sense of legal obligation. They are parties to the action as regards matters of procedure only.
Well, I'm not sure that the draftsman of paragraph 520, paragraph 1, shares your analysis of Performing Right Society and the society case, does he? Because he thought that was an example of a case where the claimant could not sue without joining the legal ass.
Indeed.
And Spokes is to the same effect as regards companies.
My lord, no. Sorry, it's always dangerous to end one's submissions by disagreeing with your lordships. My lord, as I've said, and I'm afraid I did it without taking your lordship to the case, my recollection was simply this, that in Spokes, the court, which I think was Lord Justice Ale Smith and Lord Justice Chitty, it divided as to the reasons. Yes, they both said that the company should be joined. Lord Justice Ale Smith indicated that it was a matter of necessity. Lord Justice Chitty indicated that it was a matter of procedure.
Well, unless you've got it the wrong way around, Lord Justice Chitty said to such an action as this, the company are necessary defendants.
Oh, perhaps I have got it the wrong way around then.
That's tab 57.
128. Page 128.
Yes, 128. That was in the divisional court, I think.
Court of Appeal, it said to be.
126 is Lord Justice Ale Smith.
He says the same.
Yes, I think this is a divisional court, and then the appeal is on page 131.
131?
That's the appeal. I'm not
Oh,
sure.
I'm sorry, yes. I beg your pardon. Yes, so we've got Smith in the divisional court.
Yes, Lord Justice Chitty also.
Yes. So, well, I do think I got it the right way around, but if your lordships differ on the meaning of the judgments, then so be it. But 126 is Lord Justice A.L. Smith. Bear in mind this is an application in effect for discovery, and it's a question of
Yes.
whether you have to join parties and whether they're subject to that obligation or not. But Lord Justice A.L. Smith said, 3 paragraphs down, the proper plaintiffs in such an action would obviously be the company, but in such circumstances existing, this is not possible for the impeached directors who have the controlling power in the company do not assent to the company being made plaintiffs, and without that assent, the company cannot be made plaintiffs. To obviate this difficulty, it has for many years been the practice of the Court of Chancery in circumstances such as the present to make the company parties to the action as defendants, in which action the plaintiff shareholder asks for an order, not that the damages recovered should be paid to him, but to the defendant company. And in this way, the otherwise insuperable difficulty of maintaining the action is got over. That's what's been done in the present case, and the order for discovery at the instance of the plaintiff shareholders against the company being party to the action has been made by Mr. Justice Day. That in the circumstances of this case, the company are necessary parties to the suit, I do not doubt, but without the company being made a party to the action, it could not proceed. Now that's the base on which I thought Lord Justice A.L. Smith appeared to be saying that there was a matter of legal necessity.
Yes, I was wrong actually. These are 2 decisions of the Court of Appeal.
Yes, they are.
Yes.
Because yes, they went on to consider the matter after the and also Lord Justice A.L. Smith at page 127. Again, this is in favour of the legal necessity argument.
Where we were reading before, 126.
It was 126, about 3/4 way down, isn't it?
Yeah, it's really from halfway the proper
Yes, I see.
plaintiffs down
Yes.
to 3 lines.
He says much the same on the next page.
He does. Over the page, it's really the chunk, why is not the company another party within this rule? The company are defendants in the action in order that the action may be maintained, and to my mind, are clearly a necessary party, which a mere witness certainly is not. So that appears to be an indication, contrary to my main submission, that in Spokes, Lord Justice A.L. Smith was regarding it as a matter of legal necessity. Lord Justice Chitty, on the other hand, deals with the matter as a matter of procedure, and the relevant part of his judgment starts at the bottom of page 128. To such an action as this, the company are necessary defendants. The reason is obvious. The wrong alleged is done to the company, and the company must be party to the suit in order to be bound by the result of the action and to receive the money recovered in the action. If the company were not bound, they could bring a fresh action for the same cause if the action failed, and there was subsequently a change in the board of directors and in the voting power. Obviously, in such an action as this, no specific release is asked against the company, and obviously, too, what is recovered cannot be paid to the company representing the minority, but must go into the coffers of the company.
In the old Order 11, a distinction was made between necessary parties and proper parties, and both the members of this court put this in the category of necessary party.
And presumably so did the Master of the Rolls, because he said, I say nothing.
Yes,
Yes.
best judgment of all. It's the language maintained is the language, of course, used in subsection 6b of the Act. So Lord Justice A.L. Smith talks about in order that the action may be maintained, and subsection 6b.
Well, that is so, and that's why I draw a distinction between the reasoning that Lord Justice A.L. Smith is applying, which appears to be one of maintenance and necessity to make them a party, and Lord Justice Chitty, who is looking at the consequences of not joinder, which is a procedural justification for joining them as a party. This is certainly not authority for the proposition that in a company derivative action, at common law, the company had to be a party in order for the action to be sued through. It's likely, in fact, that the issue itself simply didn't arise here. All they had to decide was that the company was a proper party. They've referred to it as a necessary party, but simply a sufficient party to make discovery in the circumstances.
But you would accept that on literal reading of 35(2), these cases would involve the addition of a new party?
I accept that they involve the addition of a new party only if by involve, one means when a court requires them to be involved. If that is the case, then even if it were the case that the general rule was that one would not engage a company, one would not make them a party, that might be the rule for various reasons, it isn't, but it might be. If it were the case that the court ordered the company to be a party, then, on your lordship's construction, it would be a claim which involved a party. And perhaps a more fable, from my point of view, way of simply raising the analogy, and these are all analogous cases, is that in the case of the equitable interest, my Lord Clerk indicated that there are many cases in which, as far as those cases are concerned, the legal party is not joined, and that happens. If it were the case that, in the circumstance of any particular case, the court were to require a legal assignor to be joined, then that would fall within the express wording of Section 35, subsection 2. And in my submission, that's a clear indication that it shouldn't be.
You have to give rather a special meaning to involving, don't you? Especially, I mean, many of these classes of case, the rules now provide that the legal owner must be joined. And it's a bit difficult to say, isn't it? At any rate, giving the ordinary natural meaning to the provision, that in the circumstances where a party must be joined under the rules, it isn't an action involving such a party.
Well, if that is right, and that is where your lordship is, why doesn't that obvious case fall within the section? Then your lordship is creating the difficulty of saying, where does one draw the line? If the order simply said, should be joined, would that fall within it? If it's may be joined, would that fall within it in a case where the court directed it should be? In my submission, whether it's must, should, or may.
So in your case, does it depend upon the facts of the particular case?
My lord, no, it depends on the true legal analysis.
So it isn't a fact-specific question?
No.
Well, otherwise you'd be up a gum tree here, wouldn't you? Because the Court of Appeal thought that this was a case in which you should, perhaps must, and would have directed the order,
Yes.
the joinder.
Indeed, it would have the perverse result that depending on whether the district judge before whom the application came to amend the pleadings thought it was better in its discretion or worse in its discretion to join a party would depend on whether the claim was statute barred or not. So this can't be a fact-specific issue. It either applies, as my learned friend says, to every case in which a new party is to be joined, or there must be a proper division as to which case it applies to and which it doesn't. And we say the proper analysis, looking at the Law Reform Committee's report, is the legal division between legally necessary parties and those joined as a matter of procedure. Having gone away from the Law Reform Committee's report, can I come back to that and just consider the way my learned friend uses this to assist him in his statutory interpretation? As I understood my learned friend, he said this assisted his analysis in two ways. The first was as follows. The Law Reform Committee assumed that in cases such as the present, the joinder of the legal owner, the person in whom the cause of action was vested, was a necessary matter. The Act was enacted in order to give effect to the report. Therefore, you should construe those categories, you should construe the Act as encompassing those particular categories. That, I think, is the first way he puts it. And the second way he put it is, well, even if that's not right, you should treat the underlying law, the need to join these people and these parties, as falling within the Act, because the legislation was framed on that assumption and the law should recognise that. In my submission, those are two fallacious approaches. The first approach is fallacious is this. The reasoning of the Law Reform Committee, in fact, was as follows. They thought that in the 5 categories set out at paragraph 5.20, all of these situations were problems. And they were problems because in law you had to join another party. Therefore, they recommended an amendment to the Limitation Act, and the amendment was not in terms of stipulating those 5 categories. It instead sought to generalise as to what the categories were. And the generalisation was that cases which involved, we say it's apparent by looking at clause 520 and 526 and 27 of the report, involved the joinder of a party in order to properly constitute the new action, where that is necessary, that those were covered by the Act. Now, if the true position in law is that you don't need to constitute an action by joining a party, then the problem never existed. And this analysis is based on a mistaken assumption as to the need to join a party in law. It doesn't change the meaning of the Act, but it simply recognises that the Law Reform Committee was in error. And as my Lord Clerk said, if my analysis of the performing rights case is right, then the Law Reform Committee got it wrong. And I do say the Law Reform Committee did get it wrong. The point to bear in mind, in my submission, is that it was never the case that joinder of parties for procedural reasons ever fell within the Limitation Act at all. And that is apparent, perhaps most clearly, from the judgment in the ILOS, and that's at volume 2 of the Authorities Bundle, tab 7. Judgment of a 2-judge Court of Appeal, Lord Justice Ackner and Lord Justice Oliver. My Lord, in this case, this was an insurer's claim for short delivery, and the insurers had sued the carriers, but they had sued them in their own name, even though the claim was for a subrogated loss. And it was held that that was a bad claim because the claim was in fact the shippers. They sought to amend their claim and also to appeal, and one can see what the amendment was at page 26, 3 paragraphs down.
26?
Page 26, my Lord, yes, 3 paragraphs down. On December the 5th, 1980, the plaintiffs gave notice of appeal and also notified their intention of seeking leave to re-amend their writ and amend the statement of claim to add the 28 buyers entitled to the 30 policies as plaintiffs and the addition of 1 claimed by the plaintiffs as assignees of the rights of the cargo owners and 2 claims for damages in the alternative by the 28 buyers. That application was refused by Mr. Justice Sheen, and the insurers appealed. Now, the problem for the insurers was that the time limit for bringing a claim under Hague-Visby had expired, and that was a strict limitation period. So the question was whether they could amend in those terms or not. And this is dealt with in the judgment of Lord Justice Oliver, with whom Lord Justice Ackner agreed, at pages 33 and 34, for your Lordship's reference, I'll simply say that the argument itself, as part of the judgment dealing with this particular point in the argument, really starts on the second column of page 33. This brings me to Mr. Irvin's second point. That's one paragraph down from there. But the relevant passage that I wish to refer to, rely on, is over the page at 34, where Lord Justice Oliver, first of all, analysed the authorities as to joinder of the legal party and drew his conclusion, and then related that to the limitation period that was being asserted. The authorities are set out in the paragraph starting. Mr. Gruder had referred us to a number of authorities, and the conclusion is really about halfway down the page after reference to William Brant's and Sons and Dunlop Rubber, which his Lordship says the case, it's true, is an exceptional one, for the settler. Debtor had in fact settled with the assignor and disclaimed any desire to have him there. He said this: nevertheless, it demonstrates the requirement is a procedural and not a substantive one upon which the assignee's cause of action depends. And then also, in fact, analyses Wilson and Ragsdale v. Steel Wing, and comments on Performing Rights Society in these words: the existence of the power of the court to dispense with the presence of the assignor in exceptional circumstances was in fact recognised by the House of Lords in Performing Rights Society and London Theatre of Varieties.
The Wilson case is quite interesting too, isn't it? I think I was attempting to put that kind of point earlier to Mr. Pont.
Yes, my Lord, so. It's an example of circumstances in which a party equitably interested can proceed to judgment. But the conclusion that his Lordship drew from that, and it should be borne in mind that in this case, the ILOS, his Lordship had held that all of the other claims by all of the insured parties were time barred. So it really wasn't a case in which they had to be joined at all for any good procedural reason. Said this on the first full paragraph on the right-hand side of page 34. The joinder is a purely procedural requirement, and on the assumption that receipts were effective assignments, which was one of the issues in the appeal, the cause of action thus vested in the plaintiffs was effectively asserted by the writ. No question of depriving the defendants of any vested right to rely on the time bar therefore arises, the suit having been properly begun within the period permitted by the rule. And my Lords, I rely on this as drawing together the cases certainly on the contractual assignment side of things, as indicating that certainly where procedural matters are concerned, the Limitation Acts simply don't apply.
So have the Law Reform Committee got it all wrong?
Well, they've certainly got that wrong. I'm not sure whether they got it all wrong.
Well, all paragraph 517, for example.
Yes, I mean the suggestion that if an equitable assignee of a debt sues the debtor without joining the assignor and the limitation period when expires, he cannot amend his pleading so as to join the assignor. The authority for that is the short judgment in Hudson and Fernyhuff. Hudson and Fernyhuff itself said, we'll give you permission to amend on terms, and the terms were that your equitable right was already there for whatever it was worth. And insofar as it's making a material point that the limitation claim will bar you from being successful, it's not supported by the authority. So yes, I do say they got it wrong.
I'd find it helpful to have the sheet of this which indicates who the members were.
Yes. Does your Lordship have it? Or would your Lordship...
Well, I'm sure we can get it, but...
Sure.
To see whether they're here at this hour.
Oh, I think that we've had this often enough, and it's a pretty powerful committee, is my recollection.
Well, my Lords, your Lordships will discover that in due course, those who don't recall it or haven't been shown it. My own recollection is that I think it was chaired by Mr. Justice Walton, who is certainly a technical lawyer in the Chancery Division. But the other members, I'm afraid, I'm not aware of. I'm sure, if your lordships would wish, we've got copies and we can have them supplied to your lordships. But certainly, insofar as your lordships want to carry out litmus testing of the quality of the jurisprudence, I can understand that. It's suggested, and indeed I think it's in our case, that it might have been thought better to err on the side of getting rid of a problem that may not exist, rather than having to deal with something which was definitely a problem. It's right to say that the report doesn't show any doubt as to what the legal position was. It's not written equivocally, it's written as if this is something which has to be dealt with. But that, of course, may seem to be the way it's been written, rather than the underlying assumptions below it. But, my Lords, having referred to the ILOS as authority for the proposition that matters of procedure don't engage, certainly that provision, the Limitation Act generally, and we would say that provision of it. Of course, that's also the view taken by Lord Justice Millett in Fairclough. And my learned friend...
Would you give the reference to that again?
Yes, it's volume 5, authority number 68.
Thank you.
Because my learned friend referred to this authority and rather poo-pooed it on the grounds that it was basically a desperate decision meant to overcome problems with the rules and therefore a strained interpretation of the Act. The Lords, in my submission, that's neither right nor fair, because, of course, their lordships look at both the Act and the rules and come to their views in respect of both parts of it. If one looks at the analysis of Lord Justice Millett, his lordship indicated, in my submission in fairly plain terms, that it was no part of the Act, the 1980 Act, to bring within its scope matters which didn't previously fall within the Limitation Act. And if one looks at page 218, I think your lordships have already been taken to this passage, yes. At letter G, his lordship says this: as I've already pointed out, there are two entirely kinds of substitution provided for by the rules. One where the party has been substituted has succeeded to a claim or liability already in the action, and one where he has not. It would be outside the scope of the Act of 1980 to alter the law relating to the former kind of substitution which involves no question of limitation. So the suggestion there is the Act of 1980 was not intended to bring situations within its ambit rather than to take them outside. And that is also carried through in his lordship's consideration of the Law Reform Committee 21st report at page 219, B to F. First of all, in my submission, this isn't, as my learned friend suggested it was, Lord Justice Millett saying the Law Reform Committee had got it right in their various heads of analysis. He's simply saying, look, this is what they said, and this is what they intended. His lordship said, if we go between D and D, the purpose of these recommendations, that is, the committee's recommendations, was to allow a limited number of amendments to existing proceedings to be made after the expiry of the limitation period, which could not have been made before. I pause there to note that should read before the passing of the Act as opposed to before the proceedings were amended. They were not intended to deprive the Court of any existing power to allow amendments after the expiry of the limitation period, nor were they intended to cover amendments which, though made after the expiry of the limitation period, were not statute barred. It would have been completely outside the Committee's terms of reference to make any recommendation of the latter kind. Lord, the rules that were then the rules which were then created subsequent to that, in my submission, also reflected the requirements of necessary joinder to constitute the cause of action. And one sees that if one looks at Authority Volume 1, Section 5, page 219.
Yes. Is this Rule 6?
Rule 6, it's Rule 6, Sub-Rule 6, paragraph A. Except in a case to which the law of another country relating to limitation applies, and the law of England and Wales does not so apply, the additional substitution of a new party shall be treated as necessary for the purposes of paragraph 5A, if and only if the Court is satisfied that A, the new party is a necessary party to the action, in that property is vested at law or in equity, in him at law or in equity, and the plaintiff's claim in respect of an equitable interest in that property is liable to be defeated unless the new party is joined. Now, that is not wording in my submission that refers to a procedural amendment which is done for the convenience of the parties. It is wording which relates to a joinder where otherwise the claim will fail because it is not properly constituted. And it's that that carries through the recommendation at paragraph 5.27 in the Law Reform Committee's report. Lords, that's the, as it were, the first point that my learned friend relied on, that the Law Reform Committee, as demonstrating the mischief. I put the matter a different way. I say that it's plain, when reading the Law Reform Committee's report, that the mischief that was identified that the Act intended to solve was that in the case of legally necessary parties, parties who had to be joined as a matter of legal obligation, they had to be provided for and a route allowed for them to get through the Limitation Act. And that is what the Act does. If joinder is not legally necessary, if there is no matter of legal obligation behind the joinder, if it's merely a matter of procedure, then that never fell within the scope of Section 35, subsection 2, and it simply shouldn't be a matter which is barred by Section 35. The alternative way that my learned friend put the Law Reform Committee and its effect was this, as I understood it. If the Act was passed on the basis that these 5 categories set out in paragraph 520 fell within the scope of the Act, then your lordships should consider that those sorts of rights, whether it's joining companies or joining legal parties, in fact fall within the scope of the Act. And in my submission, that's fallacious because it's a bootstraps argument. The law underlying the Act exists as it always has done. The Act is an overlay upon that law. It doesn't change the law, it applies it. The general rule, as I understand it, is that reports of committees which produce recommendations which generate an Act of Parliament are not themselves material matters, necessarily material matters, in considering what the underlying state of the law is, as opposed to the mischief behind the Act. And the reason for that is that committees can get things wrong, however august. And as authority for that proposition, the Lordships will find in the bundle, I think it's bundle 2, the case of Bettison and Langton, bundle 2, section 11.
Hardly needs authority, is
Sorry?
speaking for myself, I think it hardly needs authority.
It
all depends on the weight of the authors.
My Lords, the only reason I'm citing it is I'm afraid it's a familiar case, certainly to me, and that also it deals with the matter in one paragraph, so for reference purposes. It's paragraph 62 of the judgment of Lord Scott of Foscott, the very last page of the judgment. And there it is for what it's worth. The citation of Viscount Simon's dictum that the beliefs and assumptions of those who frame acts of Parliament cannot make the law, that applies to the drafters of acts as well as it applies to those who produce the reports on which the acts are based. And my Lords, I refer your Lordships to it.
I should mention that we're going to have to rise promptly at 4 o'clock.
Lord, I was just looking at my notes to see whether there are any points. First, I could jettison, secondly, shorten, and thirdly, deal with very briefly. I have, I think, 2 points, and they are quite short, and I can certainly deal with them by 4. The first relates to Latang and Cooper, which your Lordships have discussed. And this is the dictum of Lord Diplock. Lords Latang and Cooper is authority 37 in the 3rd volume of Authorities. And the dictum is at page 242, 243. His Lordship says this: a cause of action is simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against another person. It's perhaps easy to overlook in my submission that actually contains 2 elements. One is the factual situation, and the second is the consequence of that, the ability to go to court and have a particular remedy. The difficulty that this has caused really relates to the definition of cause of action in section 35, subsection 5a, which uses the following terminology. The conditions referred to in subsection 4 above are the following. A, in the case of a claim involving a new cause of action, if the new cause of action arises out of the same facts or substantially the same facts as are already in issue on any claim previously made in the original action. And the question that arises, how can you have a new cause of action arising out of the same facts if the facts themselves are all you need to generate a cause of action? The answer to this would appear to be that the cause of action does require an entitlement to a remedy. And so if by your pleading you say there is a contract, it stipulated that the other party would behave with all due care towards me, he broke his contract, failed to do that, therefore I sue in breach of contract, what you're doing is setting out the facts and claiming your remedy. Your remedy is whatever it is for breach of contract. If you should then say, for whatever reason, well, actually, I want to frame my claim in tort, in those circumstances, you would be almost certainly permitted to amend, because your claim would be a new cause of action, a new assertion, a tortious claim arising out of the same facts. It's really no more than that, where you can put a different label, a different legal label on the same facts as regards a different remedy. And that's all in my submission that is intended to deal with. The question of cause of action that I think my Lord Collins raised as regards the derivative action is perhaps slightly different, because as I understand it, the question there is the title to sue part of the cause of action? Is your right to bring your derivative claim part of the cause of action? And the answer that I would give to that is plainly it's not. And the reason is that if it were, then the limitation period would only run when the derivative action actually became one that you could bring. So if, for example, a wrong was done to a company that it could sue for, and the company then spent a year thinking about whether it should bring a claim or not, and then wrongfully decided not to, perhaps because the directors had taken a backhander from the wrongdoer at that stage, the cause of action, if you define cause of action as including your right to sue, right to bring the action, would accrue. And it would only accrue at that stage. And if one then applied sections 2 to 9 of the Act to that cause of action, you'd have a different cause of action and a different period to the cause of action that arises when the wrong is done. And that's plainly, in my submission, inappropriate and not what the statute intends. This really illustrates that the question of cause of action and the question of right to claim are quite different. And with that, I can make, I hope, the last point I'm going to make, which is to take your lordships back to the Performing Rights Society case that my learned friend referred to, volume 4, authorities. Authority 50.
Yes.
And this was a case my learned friend relied on strongly. It's important to bear in mind what this was about. In this case, a claim had been brought by a party equitably entitled to damages and a perpetual injunction. The Court of Appeal had set aside the judgment of Mr. Justice Branson, but it gave the plaintiff the right to amend its claim. That appears at paragraph 12 of the page 12 of the judgment, the speech of the Lord Chancellor Viscount Cave. What the appeal was about was not as to whether a party could be joined or ought to be joined. What the appeal was really about was about the question of costs that have been thrown away by the Court of Appeal requiring the amendment to take place. And in order to show that they didn't have to pay costs, it was necessary for the appellants to show that they shouldn't have been asked to join these parties at all, whether it was a matter of procedure or anything. And the various, as far as this issue is concerned, my lords, I'd simply say this: the relevant speeches for your lordship's purposes are the speeches of Viscount Finlay, and perhaps I'll indicate just the page references in my submission are helpful. Pages 14, Viscount Cave at pages 14 to 15.
Viscount Cave.
Cave at 14 to 15.
Yeah.
Viscount Finlay at 18 to 19 and the top of page 20. Not Lord Atkinson, I'm afraid. He deals with it really on the basis of the Copyright Act. Lord Sumner deals with it. His is the most general analysis, and that goes from pages 27 to 32. Lord Phillimore, at page 33, looking at the old Chancery practice, and also page 36. But can I turn back simply to one paragraph in Lord Sumner's speech? I asked my friend to draw your Lordship's attention to it. My friend then commented upon it, and I don't agree with the comment, so this is why I take your Lordship's to it. It's at page 29, and it's the first complete paragraph of that.
Yes.
The recognition of an equitable title or a valid title in equity and granted relief to a person so entitled without joining with the legal owner are distinct matters. The second is not necessarily involved in the first. The latter is essentially a matter of practice, and this established practice ought not to be disturbed, at any rate only very sparingly. As it is certain there is no practice to regard the joinder of the legal owner as generally unnecessary, it's for the appellants to show that it had been the practice to dispense with it in such cases as the present. Of course, they couldn't do that in that case, and therefore the judgment stood. The point that I stress is that matters of titles issue are matters of what I call black letter law. It doesn't depend on the court procedure. Unless you are a shareholder in a derivative action, unless you have a beneficial interest under a trust, unless you are an equitable assignee in respect of an equitable action, your claim will necessarily fail. So those are matters that must be proven in order for you to succeed. Lord Sumner here distinguishes that from matters of practice, as he put it, or as I would put it, matters of procedure. Those are not matters that are necessary to constitute an action. They are matters which, in the circumstances, the court says should be carried out by the parties, and the joinder of the administrator, in this case, is such a matter of procedure. Unless I can assist your Lordships further.
Could I just ask you one last question? I'd just like to go back to page 69 of, or paragraph 517 of the Law Committee report. I'd just like to have a clear note of which of these propositions you say are correct and which you say are wrong. Maybe they're all right, I don't know.
Well, I never had a Viva, but I suspect this is what it must have been right.
Paragraph 517.
517, yeah.
Well, I'd accept 517. I'd accept the first sentence. There may be. Okay. There may be cases where the existing formulation causes injustice. And when I say there may be, for example, if one turns over to page 520, subheadings 2, 3 and 5, well, certainly 2 and 3, maybe. I simply don't make any submission either way on that. I can't really comment on 5, I'm afraid. But insofar as there may be cases that cause injustice, I'd agree with that. Second sentence, if, for example, an equitable assignee of a debt sues the debtor without joining the assignor, the limitation period then expires, he cannot amend his pleading so as to join the assignor. I disagree with that as a statement. In my submission, that goes contrary to the line of authorities that most recently ends with 3 Rivers. Secondly, if the
Hudson and Ferneyhoff. Is that wrong to say?
Hudson and Ferneyhoff, No, Hudson and Fernyhough is a case in which the court decided not to allow the amendment, save on terms that the party be in no better position by the amendment, by carrying out the amendment, than he would have been otherwise. It's hard to know whether that's really a comment on the relation back principle or not. It would probably nowadays be overcome by looking at a case such as Hendry and Chart Search. But my point is that the court would nowadays allow joinder because the equitable claim could be advanced without joinder, and that if it required joinder, it would be to protect the defendant for procedural reasons, and therefore the Limitation Act would not be engaged. So the approach of Hudson and Fernyhough, we say, has been overtaken by Brandt and subsequent cases. If a person is one of two or more persons who have a joint right of action, a person entitled jointly with him, for example, a co-trustee, may be a necessary party to an action and cannot be joined after the limitation period has expired. Well, my lords, I don't think that's right.
You don't think it's right?
I'm afraid I don't think it's right, and the reason I know this caused my Lord Roger some concern yesterday. The reason I don't think that's right is because I don't think Luke and the South Kensington Hotel Company supports it. I'm afraid that's not a case we've gone through, but my criticism of Luke and the conclusion the Law Reform Committee drew from it is in the appellant's printed case. Perhaps I could be allowed to leave the matter on this basis. I don't think it's right. If I'm wrong in that, and it is right, it doesn't make any difference because we're not claiming as a jointly entitled legal party. We're not asserting a legal right.
Thank you very much.
It's really the first example, it's an important one.
Yes, Lord, yes.
Well, the court's extremely grateful to counsel for their very careful submissions, both orally and in writing. We'll take time to consider our decision.